ऐसे और वीडियोस के लिए मेरे चैनल को सब्सक्राइब करें। 3, 2, 1 स्टार्ट।
As per the guidelines issued by this court, the public servant can be arrested after approval by the appointing authority and that of a non-public servant after the approval of SSP. Stop. The reasons so recorded have to be considered by the magistrate for permitting further detention. Stop. In case of approval has not been granted, this exercise has not been undertaken. Stop. When the offence is registered under the 1989 Act, the law should take its course. No additional fetters are called for on arrest, whether in case of a public servant or non-public servant. Stop. Even otherwise, as we have not approved the approval of arrest by appointing authority SSP, the direction to record reasons and scrutiny by the magistrate consequently stands nullified. Stop para. The direction has also been issued that the DSP should conduct a preliminary inquiry to find out whether the allegations make out a case under the Atrocities Act and that the allegations are not frivolous or motivated. Stop. In case a cognizable offence is made out, the FIR has to be outrightly registered and no preliminary inquiry has to be made as held in Lalita Kumari by a constitution bench. Stop. There is no such provision in the Code of Criminal Procedure for preliminary inquiry or under the SC/ST Act. As such direction is impermissible. Stop. Moreover, it is ordered to be conducted by the person of the rank of DSP. Stop. The number of DSP as per stand of the Union of India required for such an exercise of preliminary inquiry is not available. Stop para. The direction would mean that even if a complaint made out a cognizable offence, an FIR would not be registered until the preliminary inquiry is held. Stop. In case a preliminary inquiry concludes that allegations are false or motivated, stop. FIR is not to be registered. In such a case, how a final report has to be filed in the court. Stop. Direction cannot survive for the other reasons, as it puts the members of the scheduled castes and scheduled tribes in a disadvantageous position in the matter of procedure vis-a-vis to the complaints lodged by members of upper caste. For latter, no such preliminary investigation is necessary. In that view of the matter, it should not be necessary to hold preliminary inquiry for registering an offence under the Atrocities Act 1989. Stop para. We do not doubt that directions encroach upon the field reserved for the legislature and against the concept of protective discrimination in favor of downtrodden classes under Article 15 within bracket 4 of the Constitution, and also impermissible within the parameters laid down by this court for exercise of powers under Article 142 of the Constitution of India. Stop. Resultantly, we are of the considered opinion that directions and issued by this court deserve to be and are hereby recalled, and consequently we hold that direction also vanishes Stop. The review petitions are allowed to the extent mentioned above. Stop para. Paragraph 68 of this decision clearly held that the direction to hold a preliminary inquiry issued. Stop overall.